I want to take you first to one of your first statements on the Kenya cases, where you said that your responsibility was to prosecute regardless of the status of anybody.
Well, definitely the fact that we have been trying to prosecute a head of state, a sitting head of state, has had, I believe, has had very serious repercussions on the case itself. I believe that many witnesses who would have come forward or wanted to come forward to to be as prosecution witnesses were intimidated by this fact. And even those who we had, existing witnesses, were also intimidated by this fact. Indeed, the Kenyatta case has been one that we have witnessed a very high level of witness intimidation and witness interference. And this has indeed harmed the case. It has made me to take the decision to withdraw the case. You will recall that when the case started, when the charges were brought against Mr. Kenyatta and others, the charges were confirmed. They were confirmed by 3 judges, indeed saying that Mr. Kenyatta should be called in, as well as the others, to put up his defense. Unfortunately, over time, the case got eroded. This evidence got eroded due to the fact that witnesses were pulling out of the case, and those who wanted to come forward would not want to come forward anymore. And I think to a very large extent, this is the fact that Mr. Kenyatta is now the president of Kenya has a lot to do with that.
So you think there's a difference between prosecuting a leader in power as opposed to somebody who is not in power?
If you look across our cases, you will see that we have indeed prosecuted others who, even though they are leaders, they are not in power. And therefore, we have not had this level of witness interference and witness intimidation. Indeed, in the case of Bemba, for instance, who is a leader but not in power, we have had this level of witness intimidation and witness interference. You will note that we even had to bring charges against Mr. Bemba himself and 4 others whom we believe have been interfering with witnesses. Those charges have now been confirmed before the judges, and the trial will start for, it is what we call the administration of justice, interfering with the administration of justice, Article 70. We call them the Article 70 cases. So this has happened in the Bemba case. But if you compare the other cases where we do not have a sitting head of state, where we are not prosecuting a sitting head of state, the level of witness interference in the Kenya cases is far higher. It is actually unprecedented than in the other cases we have. So naturally, one can conclude that it is because of their status, their position in power as sitting head of state, that has actually influenced or even highlighted more the issue of witness interference and witness intimidation.
How will the ICC deal with this in the future if the lesson learned is that status does make a difference?
Well, I mean, this is a challenge that we have to think about very carefully. We cannot take away the fact that this court was set up to deal with these kind of cases. This is, I mean, this sitting heads of state or leaders were meant to be prosecuted before this court, because otherwise it will never happen at the national level. So first we need to agree on that this is what this court is set up to do. What we need to look at now is what are the lessons that we have learned from the Kenya cases? What has the lesson that we draw from the fact that in prosecuting a sitting head of state, you can be confronted with this? And obviously, we try to see how we can do things differently. But the circumstances that exist in this case, if we were to go after another leader who's sitting out of state, maybe the same circumstances will still present themselves. So it is there. We can't take that away. I think we need to look carefully at how we handle the witnesses at a very early stage, how we're able to give them the protection so that they will not be exposed to this kind of intimidation. We have to rethink that very carefully. In the office, there is also a new strategy that we have put in place, learning from the experience of the past few years. And this is to also look into having alternative forms of evidence. We have realized that if all your case is based on witness testimony, if those witnesses are made to turn, of course, this will harm your case. So we're looking into alternative forms of evidence like video evidence, documentary evidence, even cyber evidence. We are looking into those to see how we can present the case without exposing as many people as possible, such as the witnesses.